I knew I'd do that often. I am Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley and Montclair, New Jersey. Today's video is my how-to series I try to do once a week, where I take a medium-sized topic and I try to give you a little bit of advice to kind of guide you through it, as opposed to my daily tip, which is a shorter, more concise piece of information. So for today, we're going to discuss what men need to do in order to get alimony in New Jersey. It's apropos because come 2019, the taxation laws in regards to alimony changed significantly, so there's a lot of talk about alimony. And in 2014, which isn't that long ago when it comes to law, the alimony laws were changed significantly. So I think it's important that we cover that. Now, I've probably done videos like this in the past about the alimony reform and even towards men and how it applies to them. But I'm going to go through it again because I think, like I said, with the new tax laws, we're going to be a lot of talk about it. So it's good to have information fresh in hand. So the first thing you need to do is understand the new law. Well, I call it the new law, but it's 2014. One important change it made was that it provided that neither party was entitled to the better standard of living or a comparable standard of living from the marriage. And that was utilized to address what I believe was a underlying bias that pervaded a lot of men's claims for alimony. And that was historically, no offense to women, but historically men were the higher wage earners, so they were more likely the one paying alimony. And the standard of review for judges was to see if the lower earning spouse, in historically most cases the wife, was able to lead a comparable lifestyle or not. They never looked at whether the person who was paying would be living a comparable standard of living. So quite often they weren't. They were living far below it in order to sustain the one that they established while they were married. So the 2014 amendment eliminated that, but more importantly what it did is it made recognition that men and women or both spouses are on equal footing for alimony. And that's significant as you go into making a claim, because I still think that despite the fact that the laws have changed significantly, the attitudes have not. Most of the judges that are still in family courts in northern and central New Jersey are many of the ones that have been there for decades before, when the old law was there and the old tax code was there. So you're still getting over the inherent bias that they carry, as well as their lack possibly of understanding of the new tax code and how that affects alimony. So the next thing that you need to do is know a little bit about the statute and the characteristics that it looks towards to determine for a court to determine alimony. Meaning, the alimony statute has about 14 different characteristics that a judge is supposed to look at when determining whether or not to award you alimony. I don't recommend that you go through all 14, usually, unless you're at a trial. If you're at a trial, you want to print out the list and actually go through all of the characteristics. But if you have an attorney or you're doing this on your own, you're in mediation, you want to look at the four main components that I think judges and attorneys look to the most. First is the length of your marriage. Second is the lifestyle that of your marriage. Third is your ability to earn. And the fourth is your spouse's ability to pay you support. Those four are going to be the most important. And there's no bright line test to how they get applied. But generally speaking, you're going to have, for length of marriage, you're going to have a short term, intermediate term, a long term, and then what used to be called like a permanent term. As a brief guide, short term will be anywhere from 0 to say 5 years. Intermediate term would be like 5 to 9. Longer term would be like 10 to 15 or 16, and then long or permanent would be somewhere in between like 15 and 20 and on. Now, the length of your marriage will usually correspond to the length of your alimony, but not equal. And again, there's no bright line rule. A lot of people look to between a half and 2/3 of the time of your marriage can be the term of your alimony. But again, there's no bright line rule. It will also depend partly on how much your support's going to be and whether or not that changes, increases or decreases over time. For instance, you may have a 20-year marriage and you're agreeing to 20 years of support, but it may be dwindling down over the years so that it's not a significant sum in the later years. People are often more willing to pay alimony longer if they're paying less. Lifestyle of the marriage, Very important to get information about that. In your divorce, you will fill out something called a case information statement. That is the document that you want to use to establish your lifestyle, but not just a document. You want to get any kind of documents to support the numbers you're putting into your case information statement so that it's its own testimony. Not as it only the information you place in there, but there's documentation to support it. Now, your ability to pay is going to be based largely on how much you're earning either now or in the last few years of your marriage. There might be an issue of imputed income if you're underemployed. Not going to go into that here. I've done videos on imputed income before, both on my website, my YouTube page. You can go there for that information. We're going to look, for today's purposes, just assume that you're earning what you should be earning and historically have. And then your spouse's ability to pay, same thing. There could be an imputed income issue there. We're not going to go into that, but it is something you should be considering. Another thing when it comes to duration, and the last thing I think when it comes to duration, is to know that the new alimony law generally states that alimony cannot be longer than the term of your marriage if your marriage is not more than 20 years. Now, what it really doesn't say is that if your marriage is more than 20 years, it can be longer. There's a discrepancy in the statute that hasn't really come up yet, but eventually somebody's going to raise it and it's going to become a significant issue. But for today's purposes, all you need to know is that your alimony cannot be longer than the term of your marriage if you were married less than 20 years. Most of the time, it's not going to be the length of your marriage anyway, as I mentioned before. Usually it's between the half and 2/3, but it can be. Now, lastly, on the term, just like most things in law, there is a catch-all in the statute that allows a court to consider any other relevant factors, which generally will take almost everything that the law says about how long it can be, the factors that you need to consider, what's not applicable, and kind of throws it out the door. It basically says a judge can consider anything that he or she wants to that might be relevant to alimony and its term. In my experience, however, it's not utilized often. It's really only for special circumstances, aberrations, egregious circumstances that really need to be considered so that a fair determination of alimony can be rendered. So you don't need to worry about it, but you should be aware it's there. You may want to be the one who relies on it because most people don't. Lastly, after you've gone through the factors and you've understood the income issues and the lifestyle and all those factors, you also then want to know the different types of alimony. One, their different types will determine how long you can get alimony for, but more importantly, it also determine when and if they get modified. Again, I've done this on a video or webinar on the types of alimony, so I'm not going to go through them in great detail. I'm going to tell you the different kinds and the reason for them, but I'm not going to go into the modifications and standards like that. That's all in a separate webinar also you can get on my website. But there's essentially, I think, 6 different types of alimony. The first is going to be open durational, which is the most common. It will have it can be determined to be permanent. The law used to say permanent alimony, but permanent alimony wasn't really permanent because it could be modified or eliminated for change of circumstances. So they changed the term, they called it open durational. What nobody in the the legislature, when they passed this, didn't realize that that's not really a word, but we call it anyway. It's open durational, which means up until it's terminated by the court or by an agreement. Second is limited duration alimony. That is specific term. It will be from the date of your divorce until a specific term. It cannot be modified in its length, but it can be modified in the amount during its term. There's rehabilitative alimony, which is also quite common. That is intended to help the lower earning spouse get back on his or her feet, usually because of lost opportunities or change in the marketplace that may have existed while the spouse was underemployed or not working during the marriage. Rehab's intended to help them get back to the position they would have been in had they stayed employed throughout the marriage. And it will terminate once they have received or once they have elevated to the place that they were intended to be. There's reimbursement alimony, which is uncommon. It is for the repayment of an asset or an obligation that was made during the marriage where one spouse sacrificed a great deal for the other to acquire an asset. Now that's the technical definition of it, but what it really is intended for the kind of circumstance where one spouse was working while the other was going to school, let's say med school. And that spouse that was working was sacrificing working on paying the money and allowing the other spouse to obtain the medical degree, which is a very valuable asset, even though most doctors will tell you it's not. So reimbursement is a way to get a repayment because the person with the degree may have a low level of earning now, but will substantially increase once the marriage is over many years in the future. The equity division of the courts say that you should be able to share in that. So it's a really good provision. I've never actually seen it get awarded, to be honest with you. I've raised it in a number of cases, but usually when it comes down to settlement, which most cases do, you're not using that term, you're finding a different term. But it's very important because it gives you an issue to utilize alimony if you don't fit in the criteria of the length of your marriage, the difference in income. If the characteristics that this court's supposed to look at don't really lend to giving you a good alimony award, and you have the circumstance where you've contributed to the other spouse's lifestyle or education, it's a good way to get the equities balanced. And the last is a term, which nobody ever really talks about because we use limited duration so often. And as I said, limited duration not usually, has a specific term. But limited duration, as I said, has ability to be modified unless your agreement language says differently. Term is not. Term is simply, it's a term of years. It's rarely have I seen people actually define alimony as a term alimony as opposed to open duration or limited duration, because they want to make sure that the laws that apply to it are tracked by the language. So you want to make sure that what you call it has matching law to it. Term doesn't have that, so sometimes it lends some ambiguity to it. But if you're making an alimony agreement that you don't want to fit into the box of definitions of the other 5 that I mentioned, you want to call it term, but then you want to specify clearly how and when if it gets modified, if at all, when it's going to terminate, and whether or not any changes will be made during your receipt of it because of change of circumstances. So that's alimony in a nutshell. Like all my videos, they're intended to help you and give you some guidance so that you know a little bit about the issue, but they're not intended to be relied on because there's too much information out there and their issues are too complex. Alimony is probably one of the most complex that you'll ever deal with in a divorce, separate from maybe child custody issues. So you really want to be well prepared. But I hope this video helps you. If it does, please give it a like and share it so that other people can see it. I will be back tomorrow, but I don't know what time yet because I haven't done my calendar yet, but I will put it up in the morning like I always do and hopefully see you then.